Hundreds of new laws are set to take effect on January 1st, and they include new guidelines on the road.
Really? Are you kidding me? Look at him!
Picture this. Margaret, a 67-year-old retired teacher from Phoenix, gets pulled over for a broken taillight. The officer walks up, smiles, and asks her a simple question: "Do you know why I pulled you over?" Trying to be helpful, Margaret says, "Was I speeding?" She was not speeding. But with those 3 words, she just confessed to a crime she did not commit. That one answer turned a simple fix-it ticket into a speeding citation, increased her insurance rates by $1,200 per year, and cost her over $15,000 over the next decade. This happens every single day to seniors across America who do not understand one critical fact. You don't have to answer police questions because you have a right to remain silent under the Fifth, and Sixth Amendments. According to the Fifth Amendment to the U.S. Constitution, you cannot be compelled to be a witness against yourself in any criminal case. This means you have the legal right to refuse to answer police questions. But here is what most seniors over 60 do not know. There are 7 specific questions that police officers ask during traffic stops that are designed to make you incriminate yourself, and answering them can cost you thousands of dollars, points on your license, and even your freedom. The officer's questions are designed to elicit incriminating answers that he can use against you in traffic court. Today I am going to reveal exactly which 7 questions you should never answer when police pull you over, why these questions are legal traps even for innocent people, the exact words lawyers tell you to say instead based on constitutional law, and how to protect yourself without appearing difficult or uncooperative. This information comes from verified sources including licensed criminal defense attorneys, the Cornell Legal Information Institute, FindLaw Legal Resources, and Actual Case Law. Every statement I make is backed by verified legal authority that you can independently confirm. Stay with me until the end because I will also share the one phrase that criminal defense attorneys say provides maximum legal protection during any police encounter. Real legal foundation, the Fifth Amendment of the U.S. Constitution states no person shall be compelled in any criminal case to be a witness against himself. This protection has existed since 1791 and was extended to traffic stops by the Supreme Court. Question number 1. Do you know why I pulled you over? The first question you should never answer is, do you know why I pulled you over? Do you know why I pulled you over is typically the first question an officer will ask you. Your answer should always be I don't know why you pulled me over. This answer doesn't incriminate you. According to attorney Robert E. Luttrell III, a practicing criminal defense lawyer, this is the most common trap question police use, and it is specifically designed to make you confess to violations the officer may not even have evidence of. Here is why this question is so dangerous. When you try to guess why you were stopped, you often admit to things you did not do or things the officer was not even thinking about. You've just admitted to 4 criminal offenses when the officer was only thinking and maybe only had evidence about one offense, assuming they had any offense in mind in the first place. A TikTok street lawyer who explains UK and international law to protect citizens explains that if you say, because I ran a red light, because I was speeding, because I was eating while driving, you have just confessed to multiple offenses when the officer might have only pulled you over for one thing, or maybe just to give you a warning about a broken taillight. Think about how this works in practice. The officer pulls you over for an expired registration sticker they saw on your license plate. But when they ask, do you know why I pulled you over, you say, was I going too fast? Now the officer has evidence of speeding from your own mouth, even though that was not why they stopped you. If you admit you were driving over the limit, you have confessed to speeding. The officer can testify that you admitted to exceeding the posted speed limit. That confession can be used against you in traffic court. The exact words to say instead, say calmly and politely, "No, officer, I do not know. Can you please tell me?" Your answer should always be I don't know why you pulled me over. This answer doesn't incriminate you. This forces the officer to state the actual reason for the stop without you guessing and potentially confessing to violations you did not commit. New California Law Update. Assembly Bill 2773 passed in 2022 now requires an officer making a traffic stop to state the reason for the stop before asking any questions. The law also extends to pedestrian stops. In California, officers are now legally required to tell you why they stopped you before asking questions. If you are in California and the officer asks this question without first explaining the reason for the stop, you can politely say, "Officer, under AB 2773, can you please state the reason for this stop?" Question number 2. Do you know how fast you were going? The second question you should never answer is, do you know how fast you were going? Admitting to speeding can make things harder for you even if you know you were going too fast. Instead of giving a straight answer, it's better to acknowledge the officer's concern without saying you were speeding. This question is designed to get you to admit to speeding, which provides evidence against you even if the officer's radar or pacing measurement was inaccurate or inadmissible. Here is why answering this question hurts you. If you say, "I was going 65, and the speed limit was 55, you just confessed to speeding by 10 miles per hour. If you say, "I am not sure, maybe 60, you have still provided evidence that you were possibly exceeding the limit. Even if you say, "I was going the speed limit," the officer can later testify that you seemed uncertain or defensive, which juries interpret as consciousness of guilt. The problem is especially severe for seniors because many seniors have difficulty reading modern digital speedometers, especially at night or in bright sunlight. If you genuinely do not know exactly what speed you were traveling because you were watching the road and not staring at your speedometer, saying so can be twisted to suggest you were not paying attention to your driving. The constitutional protection, the Fifth Amendment, gives you the right to refuse to answer questions like these during a traffic stop. You are not legally required to help the officer build a case against you by providing evidence of speeding. The exact words to say instead, say politely, "I was paying attention to the road and traffic, not my speedometer." Or simply, "I respectfully decline to answer that question." This response does not admit guilt, does not provide the officer with evidence, and protects your Fifth Amendment rights. Why this matters for seniors: many traffic tickets for seniors can be challenged if the officer's evidence is weak. But if you confess to the speed on the side of the road, you have eliminated any defense your attorney might have been able to raise about the accuracy of the radar gun, the officer's training, or whether you were actually speeding. Question number 3. Have you been drinking tonight? The third question you must never answer is, "Have you been drinking tonight?" or any variation asking about alcohol or drug consumption. This question is often asked during traffic stops to check if you've been drinking alcohol or using drugs. This question is the beginning of a DUI investigation, and any answer you give, even if completely honest, will be used to justify field sobriety tests, breathalyzer demands, and potentially arrest. Here is the trap. If you say, "Yes, I had 1 glass of wine with dinner 3 hours ago," the officer now has legal grounds to investigate you for DUI. For example, "I'm coming from a restaurant. Have you been drinking? I had a glass of wine with dinner. I smell alcohol. Please step out of the vehicle." Now you are doing a field sobriety test. No alcohol was mentioned until you said you had a glass of wine at dinner. According to attorney Robert E. Luttrell III, this exact scenario happens all the time. Seniors mention having 1 drink hours earlier, which triggers a full DUI investigation even though they are completely sober and legal to drive. If you say, "No, I have not been drinking," and the officer claims they smell alcohol, or sees a bottle in your car from groceries, or misinterprets medication side effects as impairment, they will accuse you of lying, which makes everything worse. Remaining silent is your right, but be mindful that your silence might raise suspicion leading to prolonged questioning or further investigation. Even saying "no" can create problems if the officer decides to investigate further. The legal reality: you are not legally required to answer police questions beyond providing your license, registration, and proof of insurance. This means you can refuse to answer inquiries like "Have you been drinking?" without facing legal penalties. In California and most states, you have zero legal obligation to answer questions about alcohol consumption during a traffic stop. The exact words to say instead, say clearly and politely, I am exercising my Fifth Amendment right to remain silent on that question. For example, you can politely tell the officer, I don't answer questions without my attorney being present. If the officer continues to ask you questions, you can just repeat the answer or remain silent. Or use the phrase recommended by criminal defense attorneys, I respectfully decline to answer questions about my activities. Important note for seniors, many prescription medications that seniors take for legitimate medical conditions can cause symptoms that officers misinterpret as impairment, including dry mouth, red eyes, unsteady balance, or confusion. Never try to explain your medications or health conditions during a traffic stop, as this information will be used against you. Simply invoke your right to remain silent and request to speak with an attorney. Question number 4, where are you coming from or going? The fourth question you should never answer is, where are you coming from, or where are you headed? These are not friendly questions, these are probing questions, not friendly ones. You don't have to answer them. Never lie to the officer, just politely say I am not answering your questions. According to attorney Robert E. Luttrell III, these questions may seem like casual conversation, but they are actually investigative questions designed to build probable cause for searches and additional investigation. Here is how police use your answers against you. If you say you are coming from a restaurant, bar, or social event, they ask about alcohol. If you say you are coming from certain neighborhoods, they suspect drug activity. If you say you are traveling between cities, they profile you for drug trafficking. Answering questions can lead to trouble. For example, I'm coming from a restaurant, have you been drinking? I had a glass of wine with dinner, I smell alcohol, please step out of the vehicle. The attorney explains this exact sequence happens constantly, where innocent answers about your destination lead directly to DUI investigations. For seniors, this question is especially dangerous because police often use senior travel patterns to justify extended stops. If you say you are returning from a doctor's appointment, they may question your medical fitness to drive. If you mention visiting family out of state, they may suspect you are transporting contraband. If you say you are just running errands, they may ask to search your vehicle to verify your story. The constitutional protection, the general rule is that you don't have to answer any questions that the police ask you. This rule comes from the Fifth Amendment of the U.S. Constitution. The Fifth Amendment protects you from being compelled to provide information that could incriminate you, and questions about your travel plans fall under this protection. The exact words to say instead, say politely but firmly, I prefer not to answer questions about my travel plans. Or simply, I am exercising my right to remain silent beyond providing my license, registration, and insurance. By exercising your right to remain silent, you can avoid incriminating yourself. However, if you choose to remain silent, it's crucial to remain polite and calmly inform the officer that you are invoking your Fifth Amendment rights. This protects your privacy and prevents police from using your travel information to justify searches or additional investigation. Question number 5. Can I search your vehicle? The fifth question you must never answer with yes is, can I search your vehicle, or do you mind if I take a look in your trunk? The only reason an officer asks your permission is because he doesn't have enough evidence to search without your consent. If you consent to a search request, you give up one of the most important constitutional rights you have, your Fourth Amendment protection against unreasonable searches and seizures. According to the Dutchess County Public Defender's Office, if police had probable cause to search, they would not be asking for your permission, they would just search. Here is why consenting to a search is one of the worst mistakes you can make. Once you say, yes, or, I don't mind, or, sure, go ahead, you have waived your Fourth Amendment rights. Avoid lying or explaining yourself. Anything you say can be used against you later. Even casual conversation like confirming your name or acknowledging who lives there can give officers information they may not have had before. Police can then search your entire vehicle, and anything they find, even legal items that look suspicious, can be seized and used against you. For seniors, vehicle searches are especially risky because many seniors carry items that police misinterpret. Prescription medications in unmarked pill organizers. Large amounts of cash for legitimate purposes like buying a used car or paying contractors. Tools, canes, or other items that could be classified as potential weapons. Once you consent to a search, all of these innocent items become evidence that police will use to extend the stop, call for backup, or even make arrests. The legal protection. Police officers are not required to inform you of your rights before asking you to consent to a search. If the officer searches you in spite of your objection, your attorney can argue that any evidence found during the search was discovered through an illegal search and should be thrown out of court. Your Fourth Amendment right protects you from unreasonable searches, and you can invoke this right by clearly refusing consent. The exact words to say instead, say clearly and without hesitation, "I do not consent to any searches." Decline searches, unless there's a warrant or probable cause. You can refuse by saying "I do not consent to a search." Then ask, "Am I free to leave, or am I being detained?" This forces the officer to either let you go or articulate reasonable suspicion for continuing the detention. Critical reminder: if the officer searches you in spite of your objection, your attorney can argue that any evidence found during the search was discovered through an illegal search and should be thrown out of court. Never physically resist a search, but clearly and repeatedly state your refusal to consent so your attorney can challenge the search later. Question number 6. If you're innocent, why won't you answer? The sixth question you must never let manipulate you is, if you're innocent, you won't mind answering some questions, right? Or, why won't you cooperate if you have nothing to hide? If you're innocent, you won't mind answering some questions, right? This plays on fear and pressures you into speaking without legal counsel. According to attorneys at Pointer and Buelna LLP, this is a psychological manipulation tactic designed to make you feel guilty for exercising your constitutional rights. Here is why this question is so insidious. It preys on the natural human desire to prove you are a good person, and it exploits the fact that most seniors were raised to be cooperative with authority figures. Innocent people might also benefit from involving their right to remain silent so their words are not misconstrued. The law firm Samus Law Firm explains that innocent people often need the right to remain silent even more than guilty people, because innocent people can accidentally say things that make them look guilty when their words are taken out of context. The reality is that your constitutional rights exist specifically to protect innocent people from government overreach. People familiar with the criminal justice system are more likely to invoke their right to remain silent. For example, law enforcement officers, judges, and prosecutors are more likely to invoke their rights if they are questioned about criminal wrongdoing. In fact, according to criminal defense attorneys, police officers, judges, and prosecutors themselves are the most likely to invoke their right to remain silent if they are ever questioned about potential wrongdoing. They understand that innocent people need these protections. The legal truth: many people believe that invoking the right to remain silent makes them appear guilty. However, exercising this right is a legal protection and does not imply guilt. Exercising your Fifth Amendment rights is not evidence of guilt and cannot legally be used against you in court. The exact words to say instead, say calmly and confidently, "I am exercising my constitutional rights. I will not answer questions without an attorney present. Ask for a lawyer. If questioned further, state, I won't answer any questions without a lawyer present." Do not try to justify or explain why you want a lawyer. Simply state your rights and remain silent. Perspective for seniors: people sometimes ask, won't invoking my right to remain silent make me look guilty? Maybe, but innocent people often assert their right to remain silent until they speak with an attorney. Remember that exercising your rights is not about appearing guilty or innocent. It is about protecting yourself from a system that uses your own words against you, even when you have done nothing wrong. Question number 7. Is there anything in the car I should know about? The seventh and final question you must never answer is there anything in the car I should know about? Or, do you have any weapons, drugs, or anything illegal? This is often a lead-in to asking for consent to search your vehicle. Answering no is the best policy here, as you do not want to inadvertently give permission for a search. According to criminal defense attorney Kyla Lee, who specializes in DUI and traffic cases. This question is specifically designed to make you either admit to having something or give implied consent for a search. Here is the trap. If you say, "No, there is nothing," and the officer finds something you forgot about, like a pocket knife in your glove box or an old prescription bottle, they will accuse you of lying, which gives them grounds to arrest you for providing false information to police. If you say, "Well, I have a pocket knife," or "I have some prescription medications," you have just given the officer probable cause to search your vehicle for weapons or drugs. For seniors, this question is particularly dangerous because many seniors carry items for legitimate safety and health reasons that police can classify as weapons or contraband. A cane with a weighted handle. Pepper spray for self-defense. Prescription medications in pill organizers. None of these items are illegal, but mentioning them gives police grounds to search. The legal protection: you have no legal obligation to answer this question, and answering it can only hurt you. Assert your Fifth and Sixth Amendment rights by saying these exact words: "Officer, I'd like to remain silent and I'd like to speak with a lawyer." The Dutchess County Public Defender's Office recommends these exact words to invoke both your Fifth Amendment right to remain silent and your Sixth Amendment right to counsel. The exact words to say instead: say politely but firmly, "I do not wish to answer that question. Am I free to leave?" The main takeaway from her advice is that silence is often your best defense. You can be respectful and cooperative about providing your license and registration without giving away your rights. Criminal defense attorney Kyla Lee emphasizes that you can be completely respectful and cooperative by providing your license, registration, and insurance, while still refusing to answer investigative questions. The one phrase that provides maximum legal protection. Now let me give you the single most powerful phrase that criminal defense attorneys across America tell their clients to use during police encounters. The magic language that provides maximum protection is, "I will not speak to law enforcement without my attorney present." This single statement accomplishes two critical legal functions. According to Earl Carter criminal defense attorneys in California, this exact phrasing provides maximum legal protection because it invokes both your Fifth Amendment right against self-incrimination and your Sixth Amendment right to have counsel present during questioning. Here is why this specific phrasing is so powerful. Once you've explicitly stated that you want an attorney present, police officers are legally required to stop questioning immediately. The moment you say these words, police must stop all questioning. They cannot continue asking questions, they cannot try to talk you out of wanting a lawyer, and if they continue questioning after you invoke your right to counsel, anything you say cannot be used against you in court. Your response to every question after invoking your right to counsel should be exactly the same: "I want my attorney, I will not speak to you without my attorney present." Don't answer the question, don't try to explain why you won't answer, don't engage in any way except to repeat this statement. The attorney emphasizes that after invoking your right to counsel, you must actually remain silent. Do not answer any more questions. Do not make small talk. Do not try to explain yourself. Just repeat the phrase if necessary. The complete script for traffic stops. Here is exactly what to say during a traffic stop from start to finish. When pulled over, keep your hands visible and say, "Hello, officer." When asked for documents, provide license, registration, and insurance without comment. When asked any of the 7 questions we discussed, say, "I am exercising my right to remain silent. I will not answer questions without my attorney present." If the officer continues questioning, repeat, "I want my attorney. I will not speak to you without my attorney present." If asked to consent to searches, say, "I do not consent to any searches." When the officer finishes their investigation, ask, "Am I free to leave?" Critical reminder: however, any criminal defense attorney will tell you not to answer police questions without a lawyer. The exception is during police interrogations. In this case, you can choose to answer questions and then stop at any point. According to Sewer and Associates criminal defense attorneys, even if you have already started answering questions, you can stop at any time and invoke your rights. It is never too late to assert your Fifth and Sixth Amendment protections. Final advice: your rights exist to protect you. Let me give you the final guidance that can protect you from making costly mistakes during police encounters. One of the benefits of invoking your right to remain silent is that action cannot be used against you at trial in a criminal case. In other words, if a criminal case goes to trial, the jury is never told that the person invoked their rights to remain silent or to have an attorney present. According to Samus law firm Criminal Defense Attorneys, invoking your right to remain silent cannot legally be used as evidence against you. Juries are specifically instructed that they cannot consider your silence as an indication of guilt. Guilty people often attempt to talk their way out of an arrest, which rarely works in their favor. Innocent people might also benefit from involving their right to remain silent so their words are not misconstrued. The reality is that talking to police rarely helps even guilty people avoid arrest, and it often hurts innocent people by providing statements that are taken out of context or misunderstood. For seniors specifically, you were raised in an era when police were viewed as helpers and friends, and refusing to cooperate was considered disrespectful. But modern policing has changed dramatically. Despite this clear constitutional mandate, police officers are trained to encourage people to waive these rights and answer questions. They might suggest that cooperation will help your situation, imply that only guilty people refuse to talk, or create time pressure by suggesting that staying silent now means you won't be able to tell your side of the story later. According to California defense attorneys, police are specifically trained to use psychological tactics that exploit your desire to be helpful and cooperative. Verify your state-specific laws. While Fifth Amendment rights apply nationwide, specific traffic stop procedures and requirements vary by state. Assembly Bill 2773, passed in 2022, now requires an officer making a traffic stop to state the reason for the stop before asking any questions. For example, California now requires officers to state the reason for the stop before asking questions. Check your state's current laws or consult with a local attorney to understand state-specific protections. Final thought: your constitutional rights exist to protect you from government overreach. Jurors cannot consider a criminal defendant's refusal to testify when deciding whether a defendant is guilty. Using these rights is not about hiding guilt. It is about preventing innocent people from being pressured into incriminating themselves through words that are misunderstood, taken out of context, or used against them by a system designed to build cases, not protect citizens. Know these 7 questions. Know the exact phrases to protect yourself. And most importantly, know that exercising your constitutional rights is not only legal, it is the smart thing to do.